But this year has seen more changes than the last 10 years.
We will level up your rights at work and raise your wages and your security.
They promised a wholesale of changes. A lot of promises were made that they were going to be instant. They quickly learned that it wasn't going to be an instant thing. Probation will become more prevalent than ever. Short-term absences are going to cost employers money. And he decided to fondle or grope junior employees.
Who are these employers? Do they still exist? And they
do.
They're mad. Before we get into today's subjects, over 90% of our viewers and listeners are still not subscribed to the channel. It's a massive help for us if you can like, subscribe, and comment in the comment section below. But until then, let's get on with the show. Welcome to another episode of Is That Legal with me, Paul Britton, solicitor from Britton and Time Solicitors based here in London, Mayfair. I'm joined today by
Arvin Sandhu, employment solicitor from Britton and Time Solicitors.
Good to have you here today, Arvin.
It's good to be here.
What are we going to be talking about?
So we're going to be talking about the upcoming and impending employment law update changes across 2026 and 2027.
And they've got employers...
Yeah, they've got employers...
selling their businesses,
not
running
quite
for
yet.
the hills.
They should have employers getting prepared and getting their ducks in a row. But this year has seen more changes than the last 10 years.
Do you want to tell us a little bit about yourself?
Yeah, so I've been qualified now for almost 2 years. I have a strong background in employment law. So prior to qualifying, I was an employment paralegal. Been at Britton and Time now for 2 months. And I mean, I'm sure you'll tell me better than myself, but I think it's going pretty well.
Yeah, it's going very well. I'm getting very good feedback from our employer clients. What was your journey into law?
So I'd say the first kind of exposure I had to law was maybe 13 or 14. My school ran a mock tribunal, and as I'm sure my teachers and parents will attest to, I'm fairly good at arguing. So it was kind of the grounding I needed to really pursue a career in law.
It was a mock employment tribunal,
That wasn't an employment tribunal. So the one that we did was a criminal case. So maybe I had a early interpretation impression of law was more going to be like an episode of Suits.
Okay.
So having studied it, I quickly realised that that's not the case.
Right.
And then studying it at university in particular, I found that employment law just resonated with me. I like the fact that you get to work with businesses and individuals. So you really get the duality of feeling like you've done a good job for someone who really needs it, and then at the same time you get a good grounding working with businesses.
Yeah, it's one of those areas of law, isn't it? That you can have the professional and the lay client all in one, and it's a bit of a mix each day. Okay, well look, there's a lot of changes at the moment in England and Wales in terms of employment law. And it seems like employers are always being kept on their toes by whichever government comes in. I
would agree with that. I mean, especially, Labour, their manifesto, they promised a wholesale of changes, and a lot of it was, a lot of promises were made that they were going to be instant. And then the Employment Rights Act came in, and we quickly learned that it wasn't going to be an instant thing and it's going to be a gradual thing. But now we're starting to see some of those changes come into effect.
And one of the big things they had to effectively U-turn on was the day one right to a fair process.
Yeah.
Because it was 2 years under the previous government.
Yeah.
It's been up and down all the time.
Yeah.
What is it now?
So currently now it is still 2 years. We've had some instruction on that from the 1st of Jan 2027, it is going to drop down to 6 months.
6 months. So what does that mean for employers?
So for employers, it basically means that probation has become will become more prevalent than ever. So it's about really making sure that your contract is clear on what probation will be intact, and it stretches further than that. Even before the employee walks in the door, it's about looking at your hiring policies and really making sure that the right person is the right fit. Because, in practice, it can take a period of 6 to 12 months to realise whether the employee is right for you. So employers are really going to have to not only work with their own internal recruitment staff, but recruitment agencies to make sure the right people are walking in the door, whether that be more stringent tests, whether it be more face-to-face meetings, because I know quite often now people can be hired online on a Teams call. So it's really about making sure the right person walks in the door.
The long and short of it is that employers are now going to have 6 months to decide if their employee that they've just recruited is a goer or a...
Yeah.
Do you know if there's going to be a statutory week? So if we get up to almost 6 months, is it exactly 6 months?
It's exactly 6 months.
Okay.
So it's making
So
sure
as long as you let them go a day before.
then in theory, as long as it's not for an automatically unfair reason, then you'll be fine, as long as you obviously serve the correct notice and any outstanding holiday entitlement as well.
So one of the big changes is industrial action.
Yeah.
What's changing in the world of industrial action?
So from the 18th of February, dismissal for taking part in industrial action is an automatic day one right. So previously there was a 12-week qualifying period, and it stretches further than that. I've had clients call me up and say they've heard rumours or murmurs about a anonymous ballot system. So that is also now in effect. So in practice or in reality, employers should never know who is voting to strike.
So is the anonymous system in effect now?
The anonymous system is in effect
So
now.
you can vote to strike. Well, I mean, if you participate, that can't really be anonymised unless you turn up in a Pikachu outfit or something.
No, but the biggest change is now, just say you decide to strike from the first day of employment.
Yeah.
You no longer have to wait the 12-week qualifying period for protection. It's automatically unfair.
If you're sacked.
If you're sacked, yeah. So automatically unfair means that the tribunal won't look at the process and how it was handled. Instantly, the employer is liable for that dismissal.
But then the tricky bit is that the employee has to link their dismissal to the fact that they were striking or voted to strike.
Correct.
Because they might just be sacked because of performance.
Yeah, they could be, and that kind of points to an overarching theme for employers now and employees, just to make sure that everything's documented. So keeping managers, particularly having regular performance reviews with employees, documenting everything, because quite often how these things work in practice, I know a lot of my own clients, they will do these things informally. It'll be a quick informal chat. Yeah, Arvin, you're getting on great at work. Everything's great. When in reality that should now be documented, so employers can point to specific performance concerns just to document that is in fact the reason for dismissal. And stretching further than that, the notice period for bringing industrial action has dropped from 14 days to 10 days. So
what would the punishments be for an employer who dismissed on the basis that someone had participated in a strike or industrial action?
If we're going on the assumption that is the reason for the dismissal, up until the 1st of Jan 2027, it would be under the same unfair dismissal legislation. So it'd be the lower of 118,000, circa 118,000 or a year's gross. But from the 1st of Jan 2027, the compensation limits are also being removed.
So the employment tribunal judge can punish the employer with whatever figure they feel like is appropriate.
I mean, I'm sure a judge wouldn't just pluck a number out of thin air.
Well, whatever they feel is appropriate.
Whatever they feel is appropriate. So they'd be looking at losses, they'd be looking at future losses. I mean...
And the size of the entity.
The size of the entity.
Can the tribunal impose fines?
So the tribunal can't necessarily impose fines. So what the tribunal can do is they can impose an uplift of 2 to 4 weeks. For example, if you were to bring in a successful unfair dismissal claim, and the tribunal then looked at the contract in place, so that's the standard written terms that every employee should be given on the day one of starting employment. So job title, who they report to, working hours. I have a lot of clients who, when they first onboarded, they didn't have contracts in place. And it's not an issue until it is an issue. So
isn't that Section 1 of the Employment Rights Act?
It is, but when you have employers who have been operating this way for 10, 15 years, they've had long-standing, long-serving employees who are now retiring, and standard practice was not to have the contract in place. They're just bringing in people, it's normally young apprentices, without getting those contracts in place. So I had a client who was a mechanic, been a family-run business, been operating for years, never had an issue. And then they took on an apprentice. He worked for just over 2 years, and then was sacked for gross misconduct. But because they didn't have those contracts in place, the claim was that we were unsuccessful. It didn't amount to gross misconduct of the tribunal. And then they, as well as having to pay the compensation, the tribunal imposed a 4-week uplift for simply not having written terms for the employee.
Only 4 weeks. I mean, that's the punitive. That's the punishing. So it's not compensation. It's punishing.
It's punishing on top of the.
And it's only 2 to 4 weeks.
It's only 2 to 4 weeks currently, but
how
I mean,
punishing is that?
I mean, I guess if you're an employer and you've been stung with a £30,000 to £40,000 employment tribunal fee, and you've taken it to the point where it's got to tribunal, you're you're certainly within your right to think that you've done nothing wrong. So getting a 2 to 4 week for some employers might just feel like an extra sting.
Another big change in employment law is the statutory sick pay.
Yeah, so this came in April. So statutory sick pay is now day one, right? So there's no four days to wait. And the compensation amount has changed as well. So it's moved up to £123.25.
From what?
So it was previously £118.
Oh, was it? I mean, last time I looked at that figure, it was around 90 quid a week.
I mean, it changes, I guess, inflation. It changes every year.
Yeah, so it's creeped up quite a bit. So around 120 quid now. 120.
£123.25.
So, I mean, the problem for employers is that sometimes employees just pull a 1 day sick pay.
Yeah.
A 1 day sick. And then you don't have to pay them because they're hungover.
Exactly.
And that's why you had 3 waiting days to kind of make sure they're genuinely sick.
Yeah.
With the flu or something.
So yeah, now short-term absences are going to cost employers money
From day one. And what's the maximum amount of time an employee can have under the statutory sick policy, statutory sick system?
So currently it's 28 weeks.
So we're talking...
You're testing my maths now, but we're looking at around about three grand.
You won't get much change out of £3,000. So, I mean, it's quite an expense to a business, but on top of the fact the employee isn't working,
exactly. And that kind of takes us back to my earlier point about recruitment going forward, how important it is.
Okay. This episode of Is That Legal is sponsored by Oliver Lorenz Studios, your on-demand design team for B2B service providers. They're your dedicated design partner, delivering consistent, high-quality creative without the overhead of hiring in-house. Think bold branding, polished presentations, and visual content that actually moves the needle? Check them out at oliverlorenzstudio.com. Design support just when you need it. Another fundamental change is the protections for whistleblowing. So I guess what listeners will probably want to know is, first of all, what is whistleblowing?
So in simple terms, whistleblowing is when an employee raises a serious concern about wrongdoing in the business and their employer seeks retribution or retaliation for raising such concern, i.e. they might dismiss them.
What sorts of concerns do they raise? Are we talking criminality?
So it can be anything. It could be health and safety. It could be around sexual harassment. It could be about policies. And then the key thing about whistleblowing is it has to be in the public interest. So to answer your earlier question about criminality, that's normally the number one fine for employers. It's about stopping employers sweeping stuff under the carpet.
I mean, yeah, anything that's crime related is in the public's interest to control crime in society, and there's no wonder that it actually has to be in the workplace as well. So what changes are coming in then specifically on whistleblowing?
So reporting sexual harassment.
So it's sexual harassment.
So it's sexual harassment.
Yeah.
So previously sexual harassment wasn't automatically deemed whistleblowing.
Right.
So now under the new rules, reporting sexual harassment will be a protected disclosure, i.e. whistleblowing, which means that employers are further under the cosh in terms of potential exposure and litigation risk. Because again, the important thing to remember about whistleblowing is the compensation is unlimited.
Okay, and it's not just about sexual harassment that you're experiencing. It's protection if you see someone else being subjected to sexual harassment and you whistleblow on that.
Yeah, exactly. So sexual harassment, it doesn't only extend to the individual itself. It can extend to if you and I were having a conversation and a third party felt sexually harassed by what we were discussing. That can also be classed as sexual harassment.
So if you're having a conversation that the two of you are comfortable with, but someone hears it, they can complain about your conversation, how it impacted them.
Exactly. And I guess from my own experience, I have employer clients who they might say it's quite a male-dominated industry, and the culture around the office is, to use the term, office banter. So what is office banter? Between two employees who they might be best friends outside
two
of the
loud,
business.
boisterous employees.
Exactly.
Doesn't mean that everybody else is going to see it in the same light.
Yeah, exactly that.
A lot of what's going around at the moment is the fire and rehire. What's that all about?
So, I mean, it's important to distinguish at the outset that fire and rehire should only ever be used as a last resort.
How does that come about?
So what it essentially means is if you and I had a disagreement about my contract, for example, you can't change it unilaterally. So you'd need my written consent to make any changes. So what fire and rehire is when employers can't obtain that agreement, you turn around and you say, Arvin, I'm sacking you and I'm going to hire you tomorrow on less favourable terms. And the reason it's used as a last resort is exactly that. It's very tricky to navigate, very tricky for employers to do it correctly. And the rules from the 1st of Jan 2027 is being abolished completely.
So if I had someone let's just say that they're employed from February 2027, they've got a 6-month qualifying period. If I'm not happy with their terms of contract at month 3, can I fire them and say, I'm bringing the contract to an end because I'm able to do that, no fair process, contractual rights, see you later, 1 week's notice, and then rehire them under new terms the following week if they wanted to take the job?
I mean, if you want to be faced with an employment tribunal claim, you can certainly do that.
So the answer is that's going to be unlawful.
The answer is that it's automatically unfair.
Even in the qualifying period?
Even in the qualifying period,
Wow,
it would be
okay.
automatically unfair.
So you've got to let them go and they're gone for good.
Yeah.
In some ways, that's mad, right? It's because it's counterintuitive. Because you could just sack them and say, see you later, and employ someone different to take that role. Whereas if the fire and rehire wasn't about, at least that employee would be able to get their job back under the new terms.
But yeah, it's important.
So now, but actually the employee is now, this right is excluding them from being reemployed under different terms. They've now got to go and find a different job somewhere else. But
it's important, when you say different terms, it's important to remember from the employee's point of view, those different terms are going to be a lot worse than what they were previously.
But they've now lost the ability to decide whether they want the job under those terms or not, or just have no job at all.
They haven't lost the ability. If the employee agreed to it, you can make a change, a variation to the contract with their written consent. But
under the previous regime, like if you argued with your employer and then they fired you, at least it was an option to the employee to then say, okay, look, I know you fired me, but I will take that contract because I do need a job. But now they definitely can't.
It'd be an option to the employee, but my advice and the advice...
Well, it wouldn't be an option, would it? Because if they took it back, the employer would be sealing its own fate because they would have fired, rehired, and now they could have an employment tribunal claim.
Well, that was going to be my point. My advice to employees would always be, bring a tribunal claim. Why are you going...
Well, you can't.
Well, no,
because the employer will just bring the contract to an end, you're sacked, 1 week's notice or whatever the notice period is, and now you're precluded from being re-employed. Because the employee pushed too hard.
From the 1st of Jan,
yeah,
2027, yeah.
It's not a great protection.
It's not a great protection, no. Which is why it's so rarely used in operation, even under the current rules.
It's mad. It doesn't make any logical sense. Have you got any good cases, juicy cases that you've worked on recently that are quite interesting?
So, I mean, probably the juiciest time of the year for any employment lawyer is often Christmas and the fallout from
staff party.
The staff Christmas parties.
Staff party, yeah.
So I had a case once where we acted for the employer. They were a retainer client and they had a very senior employer who'd had a few too many drinks, as he put it himself, and he decided to fondle or grope a junior employee's
right.
To put it one of a better way.
This is a male senior
so a male
on a
senior
junior
and a
male.
junior male.
Right.
Our advice was to go through the disciplinary process because the employee himself made a complaint and others had also complained about the conduct. And the employer client told us, yeah, we completely understand. And then we got a call the next day telling us that they'd actually sacked the junior employee instead. Because they didn't want to upset.
What?
Yeah, they
How
didn't want
on
to
earth
upset.
Did they do that?
They didn't want to upset the senior staff member, and the junior member of staff also he'd been working there, I think about 2.5, 3 years. So he had a very. We told them as much. He's very
bang to rights, and
witnesses, everything. And fortunately for our client, we managed to settle that one out. But yeah,
that's outrageous.
Absolutely outrageous. But yeah,
I've gone to the police. No, really. I mean, that's on another level. Sometimes I hear these cases and I'm like, who are these employers?
Yeah.
Like, do they still exist? And they do.
They do.
They're mad.
They do.
They just do the strangest things. So, for any employer that's watching, what would your 3 key takeaways be?
So the first and probably the most important one now is to do a full audit or review of your contracts and policies and get them in place. So get them updated.
How much does something like that cost?
So it depends on whether you're wanting to do a full staff handbook or whether you're wanting to do the prevalent ones that what you might find prevalent. So if you're looking at discrimination, disciplinary grievances, something like that. So if you want the full shebang, it could range anywhere between 1,500 to 3,500 plus VAT if you're looking at a fixed fee. If you add contracts to that as well, you're looking at another 2.5, 3 grand on top. So I mean, in the grand scheme of things, it's kind of a short-term financial
investment.
So it's a short-term financial investment, but for long-term, you could be saving yourself thousands at a tribunal for not having these policies in order.
Because these employment tribunal cases cost between 20, 30, 40, 50,000 pounds.
Exactly, and that was going to be brings me on to my next top tip, making sure that, especially with the 6-month time limit for employment tribunals coming in, make sure you're adequately budgeting for not only increased litigation exposure potentially, but also settlements. Because my prediction is we're going to see a lot more employment tribunal claims over the next couple of years.
And employers, I mean, to your second point, really have got to be on top of key performance indicators of those staff in those 6 months, because if they're going to let them go, they need to make their mind up pretty quickly. Exactly.
And that kind of brings me on to my third takeaway as well, making sure that your employers, you're training not only your managers and HR, but also your staff.
Yeah, I was reading an article the other day that this is going to cost, for the training side of it, employers up to £200 per employee per year.
Yeah.
And the document review, the policy review, anything from 1,000, depends on how many employees you've got, how many policies you've got, how big your organisation is, £1,000 to £10,000.
Exactly, and then you're not even factoring in the time cost of that as well. If you're having to train these employees and managers and take them out of their day-to-day fee earning, the time cost of that is, well, astronomical potentially for larger employers.
It is. All right, Arvin, well, thank you for coming on Is That Legal? So that's it for another episode of Is That Legal with me, Paul Britton, covering everything employment. We found out that over 95% of our listeners and viewers are still not subscribed to the channel. So if you could, please like, follow, subscribe, put comments in the comment section below. It's all free, easy to do, and it really helps the channel. If there's some content you would like us to produce, put that in the comments as well, and we will try and get something out. Until then, thank you for listening and thank you for viewing.